And you may be seated. And good morning. This is Cumberland 23-4, our Ernest Weidul versus the state of Maine. I see counsel are present, many counsel are present, and I assume ready to proceed. We are being streamed, hopefully, live on the web. If counsel would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Yes, good morning, Your Honors. And, my name is Hornblower. I represent Ernest Weidul. It's pronounced Weidul. Assistant Attorney General Donald Macomber for the people of the state of Maine.
Thank you. And Mr. Hornblower, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you. May it please the court, Mr. Clerk, counsel. I want to begin, I've been on this case a long time. This case is a long case. I know most of it in my head. I could probably look at it without notes. I want to start on a thing I think is a very important issue that I'm not making my main argument. I just want to make sure I get that into play here. Number one is Justice Wheeler was present during most of this case. She heard live testimony. I'm sure she observed people's demeanor, their tone of voice, their how they appeared in court, facial expressions. Unfortunately, she couldn't complete this case. Over objection, I think in an unprecedented manner, the succeeding justice agreed to take this case over reading transcripts. We think that is a grave and serious error. And without any, as I said, without any precedent, there is no way that you can read the paper there, you can look at transcripts, ever recreate whatever happened, ever reconcile when any of these attorneys said something different. And we think that's critical. And the cases cited by counsel to say you could, I think, are easily distinguishable. One of the cases, the Weidul case, that was after 2 jury trials. There was actually sort of finding of fact there in terms of the jury said he was guilty, and it was a narrow issue of appealing for a new trial. The other case was, again, after a verdict. There was a decision made, and there was a decision that involved whether a new judge could just look at the record and decide on findings of fact. In this case, Justice Wheeler left no findings of fact, made no decisions, made no other record of any conclusions about any witness. We think that alone would merit return to the docket here on a post-conviction review, but more so because of my other arguments. We believe this should either go, at the very least, to the criminal docket as a successful appeal. This is a genuine post-conviction review case. These are compelling arguments. This isn't something that I had to do because I was appointed. Over the time here, I generally believe, I think the record generally shows that there are legitimate issues here where 3 otherwise fine lawyers have collectively failed in this case. Ernest Weidul did not choose these lawyers. He was appointed to Attorney Fairfield. I think the record shows pretty clearly that she delegated responsibility then to Attorney Review. And then the record shows that when Ernest Weidul wasn't being informed or kept involved with decisions, he moved for them to withdraw. The next action was late in the case, I think 10 days before the first jury trial was to start. Attorney Conley was appointed. Attorney Conley was appointed to basically manage Ernest Weidul. And Ernest Weidul was also afforded at that time co-counsel status.
Now you're an experienced defense attorney.
I am,
many years of experience. And you know that when presented with a case, defending the case, there are different roads you can take. Some are stronger than the others. And obviously you want to emphasize the ones that appear to be the strongest. And sometimes the side roads can erode the road you're taking. You don't deny any of that. Is that a fair statement of the defense attorney's challenge?
Yes.
Now here, these experienced trial attorneys said that Mr. Weidul's prime directive was self-defense. This is where we're going with it. And they made judgment calls about the possibility of watering down that defense by chasing down these roads here. are we to second-guess those strategic, tactical decisions at this juncture here, when in fact they were found by the court below to be well-reasoned and appropriate?
No, because I do not believe these were strategic decisions. To begin with, this was the medical issues, the medical causation, the evidence there was a highway. It wasn't a side road. It was the major part of this case. And in terms of the attorney's choices, it's very important to note this. In the record of this post-conviction review, Attorney Fairfield basically testified that she made Attorney Ryu in charge of all the medical decisions and witnesses and continuances about medical issues. Attorney Rio testified that no, he viewed Attorney Fairfield as being in charge. Attorney Conley testified that he was in charge of everything. Also,
But everybody agreed that Ryu did just a masterful job in undercutting the medical testimony that was offered at the time. So why would defense counsel want to bring in more witnesses, more people to perhaps shore up the failure that Ryu was able to point out?
because these were game-changing things that were learned with this root cause analysis.
But isn't that the problem? That we don't know if they really were game-changing, because in the post-conviction hearing, we don't have evidence of what would have or should have been done differently. In other words, if a different expert would have opined differently or anything else. I mean, that's not here.
Well, it isn't just continuing to get experts in. But first of all, this was a one-of-a-kind opinion on earth by Margaret Greenwald.
I understand that, and there was some good cross-examination.
Yes, but the expert that the defense had, he was not an expert in any way in ear, nose, and throat, and he actually conceded a lot of ground here. He was also an expert that previously opined this was a Zoloft poisoning.
And I understand all that, but now don't you, in your post-conviction, don't you have to show us it would have made a difference? And in order to do that, don't you have to at least get us a report from that otolaryngologist that's going to say, I would have said something different?
These attorneys at different points during their testimony conceded that it would have made a difference in the underlying
Well, are they
post-conviction
competent
review.
to concede it would have made a difference?
They were the attorneys. They were the ones looking at this evidence. They were the one examining this
But it
medical
has to be a
evidence.
difference in the outcome, and they're not the ones testifying. And when you do a post-conviction review, don't you have to show us if they're missing evidence or how they're handling it, what it would have been or should have been?
There are factual findings here in the root cause analysis. Number one is that the tracheotomy crate was expired. That was a fact. That fact was never explored, never asked any
So
questions.
now you're really going to the Mercy Hospital report.
Yes, that the hospital also admitted that they did not identify when this decedent checked into the hospital.
I understand,
Okay,
but you're still hanging it on, don't you have to have somebody that said, and if we had done something different, if these attorneys had done something different, they would have had some testimony, some evidence that would have led the jury or could have led the jury to a different conclusion into the cause of
But I
death.
think Mercy Hospital admits at the very end that they violated the standard of care.
Every
for this
violation of
decedent.
standard of care doesn't cause harm.
But that gets you most of the way there. They admitted
It gets
their
you
negligence.
exactly half. It has to be a violation of standard of care
Listen,
and
this,
that it
I'm
made a
sorry.
difference.
This death happened 2 days after. 2 days after supposed infliction of an invisible injury that caused laryngeal edema that was never identified ever in any hospital report or study or observation. And the hospital, but we find out during the same time that there's pneumonia. The decedent wasn't even going to be admitted to the hospital. His sister insisted on it.
And I
This was-
understand all those facts, and I think they're good facts for you.
These are gross negligence. So listen, it's 2 days later, where a guy who wasn't going to get admitted to the hospital dies at the end of a hallway without any observation, without any monitoring, with buttons that don't even go to the nurse's station. His sister, God bless her, she identifies gurgling
Now
in
it
him.
sounds like you're arguing a Ray Zipsa case, but can I move you to also in the remaining time to a different point on the first point?
Yes.
Assume we agree with you that he should not have just been reading the transcripts, although I think there was also electronic recording, and I would suggest that adds at least a little bit more flavor to a cold transcript. But assuming we would agree with you, normally we would say, okay, that was error. and then we go to a harmless error. How can you say it made a difference? There's nothing here that is suggested would have been different had he not done it that way. There was no attempt to recall the attorney witnesses?
I was told I couldn't recall the witnesses unless I had new evidence. That was in the record. That was a huge point of dissension that I had. And in the record, as you will know, the attorneys at some times admitted that they made mistakes, that they could have done things, that they could have done testing, that they could have kept Mr. Weidul involved in this case, and they didn't do it. And then, in cross-examination, they backtrack sometimes. How does a judge decide who's right or wrong?
Can I ask a kind of a fundamental question
Yes.
about that transcript issue? Are you claiming that it's a violation of the rule? Or are you saying it's a violation of the federal Constitution? Or are you saying it's a violation of the Maine Constitution? Because I don't see where you identify what the basis is of your argument in your blue brief.
It's a violation of the way the courts have always dealt with this in Maine, I guess, in that sense.
Okay, well, we don't have a violation of the way we've already done it rule.
Well,
Always done it.
and I think it's a violation of due process.
But you don't even cite the Constitution until you get to the ineffective assistance. So haven't you waived a constitutional argument? And that leaves us with the rule argument. And have you really preserved that too if you don't identify what the basis is of your argument?
I included in the record, and I cited in the record, an opinion by Judge Mullen here about his treatment of this, denying the state's motion for a new trial. And I guess I would incorporate that in this argument here, too.
Well, doesn't the closest rule that we have, though, give the trial court, the judge who comes on board, takes over a case, the discretion to decide whether or not to actually have live testimony or to proceed, have a new trial, if you will, rather than relying upon a transcript?
With all due respect, I do not believe that it is a prudent or reasonable choice of discretion to decide not to see people, hear them testify, view their demeanor. That's why I did cite the case where the court previously here has just identified the intrinsic and utter importance.
So you're arguing here that it was an abuse of discretion not to order a new trial?
Yes.
Okay, understanding that's a burden, some height to it that you need to convince us of.
I believe I have laid out the grounds very clearly for that.
There don't appear to be other questions.
Thank you.
Thank you, counsel. And Mr. Macomber.
Madam Chief Justice, and for the final time, may it please the court. First, the post-conviction court properly denied the amended petition for post-conviction review. Each of the court's factual findings were supported by competent evidence on the record, and the court was not compelled to find that Weidul had sustained his burden of proving both ineffective assistance of counsel and prejudice with regard to the dozens of allegations made in the petition. Second, the post-conviction court properly relied on the record and the transcripts of the trial and the prior two evidentiary hearings after the initial assigned justice retired. Given the passage of time between the trial and the first two evidentiary hearings and the third evidentiary hearing, even the initial assigned justice would have had to have reviewed the record and the transcripts to refresh her recollection. And as has already been pointed out by the court, Weidul has shown no prejudice from the lack of the court's reliance on the record and the transcripts, other than that the post-conviction court was not able to observe the demeanor of the trial attorneys when they were testifying at the evidentiary hearings. But that's not a necessary prerequisite for a fair disposition of the petition. I'd be happy to answer any questions the court may have.
Can I ask you the same prejudice question? How should we deal with the preservation issue, given that the Constitution wasn't even cited?
I think that's a very fair point. He did not identify what the basis of his grounds were. I'm assuming he was making a Rule 25 argument, and that's what my basis is. And as Justice Lawrence pointed out, Rule 25 specifically calls for this kind of procedure. I mean, people
Well,
die.
it does and it doesn't. I mean, Rule 25 says, if by reason of death, resignation, et cetera, a judge before whom a defendant has been tried is unable to perform the duties to be performed after the verdict or finding of guilt. So it really only addresses the original trial. So unless you consider the entire, anything, including a whole new hearing, to be after a finding of guilt, Rule 25 really doesn't address this situation. I mean, it really contemplates more ministerial, i.e. sentencing, bail decisions, things like that, ruling on post-judgment motions. It really doesn't contemplate what happened here, does it?
I think it kind of does. I mean, and since that's the only, well, to the extent that there was anything cited, I think that's the rule that we have to shoehorn this argument into. So then the question becomes, what was the judge to do? Start from scratch?
Well, I think his answer is yes.
Yes.
But let me ask you this then. If we were to decide that it is a violation of Rule 25, in other words, when you're in the middle of an evidentiary hearing, that the thrust of Rule 25 is you don't get to just come in the middle of an evidentiary hearing unless everybody agreed to proceed that way. Does it require a showing of prejudice?
It does require showing of prejudice.
How could you possibly make that showing of prejudice, that you're prejudiced by a judge not hearing the evidence himself or herself?
It'd be difficult to show prejudice, but on this record, how can he show prejudice?
Well, that's my point, is if you can't, then should that necessarily be a requirement for a reversal on that
And I
basis?
think that the way that the post-conviction court handled that issue is by saying, I've got the record of what happened when, I think it was at that point, 10 years before. So I'm going to rely on that. If you have anything new, you can bring those people in. He never said I had anything new.
And that would be obviously something else. That would be a different question. But just from the mere fact of not presiding over the hearing, I'm struggling with how one could possibly show prejudice from that affirmatively. And that leads me to, should we presume it? In other words, should we not apply essentially a harmless error and just say, if it's a violation, and I understand you don't concede that it is, but
Right.
if it is a violation, that just simply warrants a new trial?
I don't think that it warrants a presumption of prejudice. I think that he would have to show some affirmative prejudice, and he hasn't done this on this record here.
But there is some dissatisfaction or disapproval of the process. As you know, the ABA standards for criminal justice address it. They say, in a bench trial, mid-trial substitution is inappropriate because the new judge would not have the opportunity to judge the credibility of the witnesses, nor to have heard the testimony in detail. Sort of setting up a situation, as the chief, I think, was leaning to, which is, if we can't show prejudice, should we just say this is a disfavored practice to the extent that we need to vacate?
You can say it's a disfavored practice if you want. I mean, as counsel already alluded to, this is the oldest post-conviction that I've worked on. It was filed in 2014, and because of the pandemic and his client's mental condition, it took forever to get through this. We couldn't finish the first two hearings because of his client's mental condition, and couldn't do the third day because of his mental condition, and then the pandemic happened. So in this unique case, it may be disfavored. Obviously, we want the fact finder to be able to observe everything.
So you're
but
saying because of the length of time it took, this case should get kind of special treatment?
I think so.
Regarding special treatment, can I ask you this? I didn't mean to cut you off, but
No, it's
I'll
okay.
ask you this. Does it make a difference that the critical testimony was from lawyers as opposed to simply lay witnesses who may be unfamiliar with courtroom proceedings and such? If the answer to that is yes, are we creating a special status for lawyers as witnesses?
Well, I think that factors into it, because really, all we're talking about is demeanor. The court had access to everything that the lawyers said. So really, I don't see what the harm is here, other than that the Justice Anderson didn't get to see the three lawyers testify at the evidentiary hearing. He saw everything that they said from reading the transcripts.
And that's where I'm kind of getting a little bit tripped up here, because from what you're saying, it really sounds like, given that, no one could ever show prejudice from that.
Going to be difficult to show prejudice, no doubt about it. I think in the unique circumstances of this case, I don't think there's a problem.
Well, this is not a case where there is a material disputed, he said, she said, black and
Absolutely not.
white fact case.
Absolutely not.
And so if we kind of look at the Civil Rule 63A, it says, you recall any witness whose testimony is material and disputed and who's available to testify. So it would, here, if we apply the civil rule, is there any material disputed testimony here as opposed to here's what they did, here's their explanation as to why they did it, and maybe that's how you show prejudice when it's a black and white issue of credibility, when it's not credibility that's important, you don't.
I think that's a very fair way to characterize this.
But if we borrow from the civil rule, part of the standard is there, whether or not the witnesses could be recalled without undue burden in a civil case. And, witnesses, lay witnesses move away, they die, all sorts of reasons why they can't come back. But the lawyers are still here. They come to court all the time. So it's really, if we borrow from the civil rule, and if undue burden is the test, and you've pointed out the length, it's been very long, but the burden of bringing them back in is not very great.
That's true, but what would be the point? Just so they could repeat everything that they said
Well, it may be,
beforehand?
because the rule, if we also borrow from the civil rule, it says it's not really a discretionary call on the judge, it's the judge shall recall at the request of the party, assuming the testimony is material. And obviously, the attorneys in this case, those witnesses have to be considered material. There were some disputes, as you said, they changed there was some change of testimony on cross-examination, and presumably, unlike some lay witnesses, we actually know where all these people are.
Well, that's true. We do know where these lawyers are, and the civil rules aren't applicable here. I go back to, and the cases I cite, I mean, there was a mid-trial separation where I think the judge died in the middle of the trial, one of the cases that I cited.
Do you wish to comment on the status of post-conviction cases on the docket? As you know, we have a very active docket for cases that are coming the first time, and sometimes it seems like the PCR cases maybe languish a bit, or there's other fires that need to be put out. I don't know what the situation is in your office, or whether they get short shrift, or the primary attention is to the current cases coming in. You don't have to, but perhaps as part of your exit interview, you may want to comment on the status of the docket.
There's no question that post-conviction cases reach the bottom of the barrel in terms of priority, but as the court knows, given the backlog, I think that when you have people in pretrial status languishing without trial, of course the court has to prioritize those cases. I've expressed a lot of frustration over the years about how long it takes for post-conviction cases to go from point A to point B, especially in a case like this where, and I want the court to give Mr. Hornblower a lot of credit in this case, because he's languished on this case for the better part of a decade, along with me, and through no fault of his own. And when you're dealing with someone who fires their lawyers at the drop of a hat, as what happened pre-trial and in this post-conviction matter, there's some cases that take longer than others.
So let me take you back to this case specifically where it took so long. I believe the PCR court made a finding that there was no issue with respect to any disorganization amongst the attorneys who were representing Mr. Weidul. Yet, as Attorney Hornblower pointed out, A didn't know what A was saying. B was responsible for the medical evidence, and C came in and said, no, not them, it was me. And this is in the context of the case in which the medical evidence, the root cause analysis that came in at the 11th hour, potentially, we don't know, we don't have an expert telling us what the impact might have been, but potentially could have turned the circumstances of this, this case.
Well, that's true, but as you pointed out, it was his burden, or I think it was the chief that pointed out that it was his burden to show what the difference would have made, and he didn't make any showing that if
Well,
I
the chief
called this
also
person-
suggested that perhaps in this sort of a case, given the circumstances where we hadn't had a completed final judgment, if you will, maybe we should assume or presume in that circumstance that there was prejudice, especially when, since you have the PCR court making a determination in the context of a central issue to the case that may be inconsistent with what the actual trial, the record evidence is.
I don't think the the post-conviction court, each of the findings, factual findings made by the post-conviction court are supported by testimony in the record. You'd have to find that it was clearly erroneous for the post-conviction court to have reached that conclusion. In terms of the medical evidence, we have no evidence that they had somebody that was going to say something different, or why this Mercy
They
Hospital
didn't really do
evidence.
anything with the Mercy.
They did nothing, but it came in,
Isn't that right there sort of problematic?
not necessarily, Your Honor, on the context of this case, because as Connolly testified at the post-conviction hearing, this case, and at trial, this is self-defense, and we also, if you don't buy self-defense, we also have causation in terms of, was it laryngeal edema, or was it
Well, and it certainly
Something
started as
else.
self-defense, but I mean, it seems like, especially with the addition of the Mercy report, suddenly the issue of causation is really taking central stage at that point.
And
Maybe it didn't earlier when they were preparing.
relied
but-
on Dr. Beliveau to establish the causation issue, and given the timing of the Mercy stuff, and it really wasn't that critical to the issue, so they made a tactical decision, they were going to rely on Beliveau, and as Justice Meade pointed out,
But the assumption that it was a tactical decision is based upon their testimony. And if review here is for harmless error, which I think it is, can we assume that if the same judge had heard all the testimony, that the judge would have found the attorney's testimony about the failure to pursue DNA evidence, the failure to hire an otolaryngologist, the failure to jump on Mercy Hospital's analysis, all of those were tactical decisions? Can we assume that? And don't we have to assume it in order to reach a harmless error conclusion?
I think you can assume it, but each of the findings that you just talked about are supported by testimony in the record. And you're going to have to find that the post-conviction court was compelled to reach a different conclusion.
Thank you, counsel.
Thank you, Your Honor.
Mr. Hornblower.
Begin with, thank you, Don Macomber, for his service here, and I was enjoying working with him. I want to correct something, though, and wish him the best. And I haven't languished on this case. This case has really motivated me, because this case illustrates why these cases should not be at the bottom of the barrel. This is an important issue with important case. First of all, in terms of the strategic, there's no strategic decision in not getting confession or admission from someone. It's the most powerful evidence going. And there was no days after this where Tina Rio could ask any medical person any of the questions ever. There's no strategy in that. It can't possibly be. Secondly, unless I had a videotape running of the witnesses, their demeanor, their tone, their expressions, their reactions, I can't show you that prejudice. I wish I did, and that's the essential fault of this case, and that's why it took this judge 39 pages here in this complex case to try to, I think, incorrectly reason that we hadn't proven our case.
Does the fact that the witnesses were lawyers, is that something that we could or should consider in this? You wanted to bring them back and have them testify again. And what's going to be served by that? Just their demeanor, the way they're talking, their body
I
language?
think their demeanor, when I was there, I saw how they testified. I saw Attorney Rio say, yes, I made a mistake. I should have done this. We failed. Hello, that's powerful evidence. I just want to point out, Your Honor, in this regard, when Attorney Connolly came aboard here, 2 days before the first jury trial, 10 days before, sorry. He said this case was the MCLS billing, this case was in crisis. It was runaway. The defense, 10 days before the first jury trial, had not been developed adequately. He called it a battlefield. He went on at length to describe all the efforts he had to do to straighten this case out, and I guess that's why he said he took control of it. Also, these attorneys' testimony is, after Attorney Collins came aboard, they never met, the other attorneys never met with Ernest Weidul ever again, who had co-counsel status in this case. And during the trial here, Ernest Weidul was allowed to go to sleep. I can't imagine what kind of an effect it had on the jury. Thank you.
Thank you, counsel. As is our usual practice, we will take this matter under advisement and issue a written decision in due course. But, of course, we